because it makes it where we can actually hear what everybody else is doing when only the participants are muted. My second request is that we try to, if we can, address Mr. Blair's case, because he's the only person I've got in Taylor County, and they've been on here waiting for a few minutes. And so if I can get that one taken care of and get them moved on to whatever else they need to be doing over there, that'd be great. I've got
Judge, I
Hardin
believe
County.
that is Reese's case, and I can't, she might still be on district court. I can step in the office, see if she can log on real quick.
Okay. We also have Hardin County Jail, and that, I know that's Mr. Richardson's case, but I don't see his, the attorney that's involved in that case. I don't see him on here right now. So
He told me he could be here today, Judge, and I did send him the Zoom link, so he might be tied up. I'm not sure.
so we may not be able to get either one of those taken care of right now. Oh, there's Risa right there. Okay, let me let her in. All right, Ms. Gardner, I wanted to just try to start out talking about Mr. Blair's case, because that's the only individual I have in the detention center up there in Campbellsville. So I thought maybe we would try to get that taken care of so that I could let them move on. I don't remember who's involved in it. Is Ms. Myers involved in it on the?
Yes, Your Honor.
Yeah. I don't know if there's anything we have to discuss, but here we are. So let's find out.
We've been negotiating back and forth. I don't know where the defendant stands as far as our latest offer.
I haven't been able to actually discuss with him the most recent offer. We've kind of went back and forth, Your Honor. I would like to have an opportunity to convey Reese's most recent offer to him and see if he wants to accept that or not.
That's fine. If we want to pass it for however long you need in order to do that, that's fine with me.
I think I can get through to him this week. I just didn't have enough time from the time of the last offer.
Okay.
All right. You want to look at, excuse me, we will not be having court on Monday, April 5th. So we could look at either the 12th or the 19th. Either one of those is fine with me. Ms. Myers, it'll just kind of depend on your preference.
I think the earlier the better, Your Honor. I know he's coming up for shock probation, and I'm not sure exactly when that will be. I think the last time he was before you, he brought up requesting that you look at his bond. If the 12th is not prior to his motion to shock probation, I'll just kind of reserve that motion. Brandon, is that right? Are you coming up for shock probation after the 12th, or is it before the 12th?
She hasn't given me a court date yet. I just know it's gonna be sometime this month. The court date's here, the way they've been going, we don't know for sure.
Okay. If we could just go ahead and set it for the 12th, Your Honor, I think that'll work.
All right. We'll do that. And then we'll talk about whatever we need to when we get here on that day.
That'll be at 10.
That'll be 10 o'clock on April 12th.
Okay.
Okay. All right. Thank you. That concludes our business with the Taylor County Detention Center, so I can let those folks leave.
Okay, thank you, Your Honor.
Thank you very much. Let's see. I don't have anybody else waiting. We've got a few individuals on here that I think we were going to try to, possibly do arraignments on. I know Miss Gossett, she's come to 2 or 3 different Zoom meetings. And I believe today is the one she's actually supposed to be at. So I know we can do her arraignment. I'm not sure who else is on here for an arraignment, because a lot of these don't have names.
I also had Michael Riley for arraignment, Judge. And Noah Wilson as well, but he's in Barron County Jail.
Yeah, he's in jail. Yeah. Ms. Gossett, can you hear me?
Yes, sir.
All right. Can you tell me where you are right now?
I'm at New Path in Bowling Green, the
Okay.
sober living home.
All right. Let me get you on up here. Okay. So can you tell me what your address would be if you were not there?
If I wasn't here,
Yeah, like where are you going to be living on a permanent basis if you know?
oh, I don't know. I'm gonna, like, once I graduate here in 5 months, I'm gonna just be getting my own place here in Bowling Green.
Okay. So you don't really have a permanent address or
Right.
that you know of right now.
Right.
All right. Can you tell me the address to that location?
It's 1625B Catherine Drive, Catherine spelled with a C,
Okay.
Bowling Green, Kentucky, 42101.
And just one more time, the name of it is what?
New Path.
New Path?
Yeah.
All right. Thank you. Ms. Gossett, you're here, as you know, because you have an indictment out of Barron Circuit Court, which was returned back in January, charging you with the offenses of trafficking in a controlled substance, first degree, 2 or more grams, first offense, and possession of drug paraphernalia. Those are respectively a Class C felony and a Class A misdemeanor. I can't remember who your attorney, you already had an attorney from the DPA, and I cannot remember who it was. Do you happen to remember?
I have Candace Hill for Pendleton's court, and then I have Robert Austin for Metcalf's court.
Okay, so your case was over in Metcalf County, and yeah, that was Mr. Austin. So let's see. Greg, who will we?
I think Mr. Price is going to represent her on this one.
Okay,
He's a conflict attorney.
Mr. Price, are you with us? I saw your name on here, but you might be busy doing something else.
Oh,
We
I'm
have
on here,
not-
Your Honor.
We have not officially sent it yet, so he's not really aware of the case, but it will
Okay.
be.
Well, allow me to be the second person to tell you that you're going to get this case.
Mhm.
Mr. Berry was the first, and he's beaten me out again. But this is Miss Gossett. She's you probably weren't listening to all that because you didn't think you needed to be. She is currently in a long-term
Oh,
residential treatment plan over in Bowling Green, which we all knew about because she had another case with us that was over in Metcalf County, and that was part of her. She had an issue on bond, and that was part of how we resolved that, was to get her, which she voluntarily agreed to do, the way I understand it. So I think things are going pretty good. She's tried to get on almost every court, every rule day we've had for the last month, because she didn't want to miss it. This is the one she's supposed to be on. So good on you. You're here. Do you wish to have me formally arraign her with explanation of rights and charges, or do you want to waive that and move on?
Ms. Gossett, I know we haven't spoken, but I would ask that we just waive that. I'll get you all the information you need, get you a copy of the indictment, and I don't think the court should read it. Is that all right with you?
Yeah, that's fine.
Okay.
Judge, go ahead. Sorry.
Oh, no, that's fine, Your Honor. We'd waive that, and I can't acknowledge her, but I think the court's very aware of her identity, and we just asked to enter a not guilty plea, get discovery, and get a pretrial hearing.
Yes, sir. Mr. Richardson, what do you got?
She's got a co-defendant, which I guess is the reason for the conflict. It's Benton Price, and his pretrial is set on May the 17th. I know she mentioned she was getting out in May. I'd like to put it on that same day to keep them together, Judge.
I think you'll still be where you are in May, won't you?
Well, I've been here for a month already. Well, a month and a week already. So it'll be like right about 5 months. I'll be able to leave here.
Judge, just so we don't lose track, I'd like to put it on that same day. So that way, if we have to continue Price, I'd like to keep them both together. So we're not putting them on separate days. If she's still there in rehab, obviously, I mean, I wouldn't expect her to show up on that day, but.
Yeah, I'm just trying to keep it all straight in my mind. I thought that now she might be able to travel or something by then or however, I don't know, every one of them has kind of their own rules, but
Yeah,
I got the impression that she was going to be in there until around the end of the summer at least.
yeah, I will be, but where I live at the sober living house, I've already graduated actual treatment. So like,
All right.
I do have employment. I am able to leave and things like that.
Good. Here's what we're going to do. I've got Mr. Price that we're appointing to represent you. Mr. Price, tell her or ask her whatever you need to while we've got you both on the same call so that you can.
And Ms. Gossett, do you have something to write with?
Yes.
My cell phone number is area code 216-534-1422. And can I get a good phone number for you?
It's 270-576-1430.
Thank you. And
All
Your
right.
Honor, I wasn't paying attention at the very beginning. Could I get this case number again?
You can 21 CR 019.
Thank you, Your Honor. And I think I would agree to the 17th too, Your Honor. I'd ask to just keep them together.
Yeah. And Miss Gossett is going to be in Miss Gossett, be sure that you maintain contact with Mr. Price, and then
Absolutely.
he'll kind of keep you in the loop of what's going to happen when we come back on the 17th. If we're not gonna, I think Mr. Price, this is confusing. Your co-defendant is also Mr. Price.
Yeah.
And I think that your co-defendant is in rehab also, correct?
Yeah.
Yeah.
He's still in treatment.
So it's a good chance that maybe we'll be bumping this, but I don't want you to come here for nothing, but you all can just be sure you talk before then.
Okay.
You
So
take
what's
care of that.
the date?
May the 17th at 1:00 in the PM, and we will be, we all anticipate that we'll be meeting in person by then and not on Zoom.
Okay.
Don't say that, Your Honor. The second you say it's not going to happen.
Well,
Well,
that's why I just said anticipate, because that's a factual statement. Now, whether it happens or not, I'm not going to make any promises, but I anticipate it will.
well, as of right now, by that time, like me and my co-defendant both, we will be able to like leave from where we are to
And
attend.
Miss Gossett, I got to advise you. I mean, I appreciate you giving us the information, but let's hold off on the conversation. We're going to talk about that, and we'll have a better idea of what's going to happen.
Okay.
We can make any changes we need to, okay?
Okay.
Yeah, just stay in contact with your attorney and he'll keep you in the loop, okay?
All right. Thank you.
All right, Miss Gossett, keep up the good work. You're free to go.
Thank you.
Take care, Miss Gossett.
All right. See what else I got on here.
Come on, Judge A, pick me.
Your Honor, could I ask really briefly if I could get Mary Colvin's email address? We've not been able to send her her PSI, so I'd like to send that to her so when we call her, we're ready.
Mary? Can you hear us?
Yes. Yes.
Yeah. Can you give them your email address again? Something didn't work.
Okay. Do I need to go offline and do that? Because I'm not sure. I don't know how to work this. I don't know how to do all this mess.
Can you just, do you know it? Can you just say it? Or,
Yeah. Yeah. I thought I needed to type it. Sorry. It's
No.
Mary Lynn 923 1963 @gmail.com.
Okay,
Did
I'll
that
try
work?
to get that sent again and see if it'll go this time. Thank you.
I got a bunch of writing that you sent me the other day that I checked over
Oh, okay.
what I could tell of it. Yeah, what I could tell. I can't see real good because these are just reading glasses, but what was that? What it was?
Yes, that should have been it. I just didn't think that it went to you. So yeah, we'll come back to you then when the judge is ready. Thank you.
Okay.
hey,
All right.
Mary,
Thank you.
Mary,
Yes, sir.
stay right there.
Oh.
I'm going to ask you something.
Wait a minute. Yes, sir.
Is the thing that you got, did it look kind of like this?
Yes, it did.
All right, good. All right. We'll get back to you in a minute, okay?
Okay, thank you.
Thank you.
Now I'm gonna try to mute this again. Oh my goodness, what have I done? Now I
Hold
went clean.
on. Hey, Mary. Oh, Mary left us. Lord Almighty. We hardly knew you. All right, here's Mr. McGee. He's rolling in here for Miss Bryant, so we can get Hardin County up and running. Thank you. Mr. McGee's coming into my meeting here. All right. Well, thought he was. Mr. McGee, can you hear us?
Yes, Your Honor. And I just got out of Judge Calvert's court in Family Court 9, Your Honor. My apologies.
No, that's okay. We were picking these off one at a time, and we've just gotten down to where we can deal with Miss Bryant. So my understanding is that what we're here for is the Commonwealth motion. Back when you asked Mr. McGee for me to send Miss Bryant for an evaluation, we talked about this MCMI, I guess is what it's called, and I put in the order that I would like them to apply that or administer that. I'm not sure that, I guess they've asked the Commonwealth for me to take that out. Is that it, Mr. Richardson?
I mean, basically, they contacted me like a few days after you sent the order, Judge, and they were saying, you know, as I put in the motion, but I'll put on the record here that this MCMI-4, it's a test, they said, that's normally used in clinical settings, you know, when someone's already been diagnosed and they're looking for other treatment options. They said it's not reliable in a forensic setting, meaning, you know, when the court's asking for them to figure out criminal responsibility and whether they can participate in their own defense, it's not something that's reliable. And they even sent me an article from the textbook that they use, and I've enclosed and attached a copy in the motion and sent it to Mr. McGee as well, that states so. So basically they said that they were, they could just do what they normally do, but they did not want to, even though you were asking, which is what I told them, they said they'd like to have some clarification because they've tried to do that before where it's been, asked and they didn't do it. And then they had a show cause motion served on them. So they were asking for that to be clarified and to be removed, Judge.
Okay. Mr. McGee, do you want to say anything?
Very briefly, Your Honor. One, I do appreciate counsel sending me a copy of the motion and the notice, specifically with the attachment indicating that they had concerns about the reliability of the test. I will tell the court, having researched this issue, was one of the reasons that I asked for the court to recommend that test, is that the opinion regarding its liability is not universal. In fact, there are courts throughout not only our region, in both state and federal court, but in different parts of the country that have used that test in a forensic capacity. I know that KCPC indicated that they're not comfortable with it. They believe that there is reason to question it, but I will say this. I don't want it to interfere with the ability of this court to make an independent assessment. And if that test is going to be the holdup, then certainly the court can withdraw that portion of the recommendation from the order. Having said that, though, I do know Ms. Bryant would like that test administered. If we have to go through a private clinician to do so, then we'll do that. It just seemed more convenient to have the testers at KCPC actually administer it. Part of the problem, Your Honor, and I told this to my colleague, is that test is an expensive one, not only to request, but to administer. And I think this has more to do with the expense involved than any questions about reliability. That test has been around since the late 1970s. It's been updated. It's referenced in the current DSM-5, so it's a reliable test. But it is an expensive one to administer. So again, I don't want that to interfere with the evaluation, though, Your Honor.
Yes, sir.
And Judge, just to clarify on our end, what KCPC has relayed to me is that it's not the expense, it's that it's a test that they would not use, and I'm putting that mildly, for this type of, for forensic testing.
All right, let me say, I mean, we're not going to spend a lot of time on this. Mr. McGee in his motion acknowledged that this is not universally accepted except in clinical settings, and I knew that when I put it in the order. I'm not going to just blindly accept whatever KCP. I mean, you all have done enough of these to know we have hearings and they testify, and sometimes I don't agree with what the testifying physician or psychologist says, and sometimes I do. But I mean, I'm going to make my own assessment. I have a background in psychology, and I just because they don't think it's up to me to decide whether the test results are relevant. And I don't think it's up to them to decide whether or not they ought to comply with the order. I appreciate that they contacted you and asked you to clarify that, but just to make sure there weren't any questions, and I'm certainly not upset about that. But I mean, I want them to do that test if they're able to do it, which is what the order said. And I will, they can testify all they want to when we have the hearing about whether they believe that it is relevant or valid, that the results are valid in a setting such as this. And I will certainly take that into account. And I might completely agree with them after they tell me why they say that. And I might completely disregard whatever the results are. So, by the same token, the results might show that she's completely competent to stand trial, which is the main issue that I will be focusing on. So, I'm not going to just blindly accept whatever that test results are, and I'm going to allow them to explain why they feel like the test results might not be indicative of her abilities, but I still want them to do the test. I know how these things operate, and I will put the weight on it that I think I need to put on it after hearing what everybody says about it. Okay?
All right, thank you, Your Honor.
All right, thank you. And I'm not going to do another order on that. I'm just going to note here that after hearing, the motion was denied. All right, Ms. Bryant, we got that taken care of. Thank you.
Thank you.
Let's see. Can we get probably need to start dealing with our inmates.
And Judge, when you start, if we're on the Barron County Jail, we had Brandon Coy on for a revocation hearing. I had a deputy from Edmonson County that was standing.
Okay. Well,
however you want to do it. I mean,
isn't Mr. Coy in Hart County?
Oh, I'm sorry, Judge. Yeah. Well, I guess that should have been my question is, are we going to have Hart County on here? Because now that I'm looking, I don't see them on here.
Well, this is the one, when I said it, I told you all to subpoena your person for 11 o'clock because Hart County said they couldn't get on till 11 o'clock. And so I said, well, we'll still be having court. If you can't get on at 10, we'll just do it whenever you can get on. Because they have district court from 8:30 till usually about 11.
Okay.
Yeah. So I mean,
sorry.
Your witness can come back if he wants to at 11 or thereabouts, or he can just kind of hang around in the background till we get there. It's fine with me either way.
Okay.
Okay.
I'll be back at 11. Thank you, Judge.
All right. Thank you.
Your Honor, can we handle Eric Martin's case real fast before we do the jail? I think he's on here.
Yeah, I think he is too. Although I don't think he's got any audio.
Well, what I was going to ask is to continue this to the 12th because I have not been able to get his PSI and I need to talk to him some more before we go through his sentencing because I think I talked to him last week. There was some confusion about what was going on, so I need to clarify some things with him before we proceed with sentencing.
Your Honor, I don't necessarily have an objection to that, but I know that the reason why his diversion was voided and why we're here for sentencing is because payments were not being made, and wanted to know if there had been any payments made.
There was, and I would have to go back probably to figure out how much he was supposed to pay, but there has been $300 paid since
Okay.
we talked last. So that was certainly a lot more than what was getting done beforehand.
Okay, thank you.
On the 16th of March, there was a $300 payment made. So I don't have a problem passing it for 2 weeks. Josh, he's gonna have to, this was the same issue we had the last time. He didn't have any sound.
Right.
So we'll have to get that figured out, because I mean, I can't sentence him. I can't just assume that he has nothing to say. He's got to have a chance to say it. Yeah.
I'll see if I can get that fixed as well, Your Honor. I'll see if me and him can work out something to where we can get that fixed in the next 2 weeks.
All right. So April 12th? Is that what
Yeah.
that day? Yeah, April 12th, 10 a.m.
All right. Thank you.
All right, let's get back to all right, you want to do Quentin Ellis?
That's going to be my case, Judge.
Okay. All right. You are Quentin Ellis?
Yes, sir.
Mr. Ellis, can you tell me your address?
My permanent address is 111 Clark Street, Glasgow, Kentucky, 42141.
Okay. Mr. Ellis, you're here because you have been indicted on account of burglary in the second degree, a Class C felony, fleeing or evading first degree, a Class D felony, resisting arrest, a Class A misdemeanor, public intoxication, a Class B misdemeanor. Do you need to have me appoint an attorney to represent you?
I thought I was already, well, I guess because I sent it to the grand jury, it wasn't finalized, but I thought Robert Austin was already my DPA.
Okay. Yeah. Now that you have been indicted, it'll probably be a different person from that same office.
Okay.
So, Mr. Berry, I will go ahead and continue the representation from your office, and you all can just assign that internally however you need to.
Okay. This will be Josh's.
All right. Mr. Spears, you with us?
Yes.
All right. Mr. Ellis, does Mr. Ellis wish to waive formal arraignment?
Yes, we waive formal arraignment, enter plea not guilty, request pretrial conference and discovery.
All right, so not guilty plea, pretrial conference. I think we could probably do, let's do May the 24th.
Okay. Judge, can we address bonds once we?
Yes.
Is there currently any other holds on him, or is this the only thing holding him?
My recollection was that he had a hold out of Warren Circuit Court.
Okay.
Yes, Your Honor, that's correct. I'm showing he's got a $5,025 cash bond, and that he goes to court again. He went February 23rd and he goes back on April the 5th.
Okay.
I'll-
think-
I'll just-
I think our bond was set at 2,500, which is, fairly low for a Class C felony, second degree burglary. If it would make any difference just to pre-address it, I could probably agree to do a 10% on that as long as he was being monitored by somebody, which
Judge.
Marion County would be U-turn.
Judge, if I could be heard on that, I do
Yes.
think where the bond's at is where it should be set, considering he has 2 pending cases in Warren County, and one of which is also a burglary second degree. The other is a receiving stolen property. Obviously, he's presumed innocent, but the nature of the charges are very similar. His bond in Warren County on the burglary case is $5,000. So in comparison, ours is less than that. If he were somehow to make that bond in Warren County, I think we could do something then. But just due to the nature of the charges, I think $2,500 is fair.
Yeah, I understand it. And I'm just trying to look ahead to whether or not, I don't know that bond's going to change it all in Warren County, but since I'm putting this pretrial 2 months away, I was just trying to,
Okay.
make some kind of accommodation just in case it did. If it doesn't, then anything that I do is not going to make any difference.
Thank you, Judge.
But I will, Amy, if it's, I need to specify just in the chance that the bond is made, that it's going to have, random drug screens and reporting to U-turn and that kind of thing. Okay.
Yes, Your Honor. Thank you.
All right. I don't know if that's on it right now or not on the paperwork that you have, but all right. So we will be back on May 24th at 1 o'clock. Okay.
All right. Thank you so much.
Dustin Furlong. All right, Mr. Furlong, you are here because you have been indicted on 1 count fleeing or evading police first degree, 1 count of operating on a suspended license, 1 reckless driving, and failure to illuminate headlamps. Those are respectively a Class D felony, a Class B misdemeanor, and 2 traffic violations. Do you need me to appoint an attorney for you?
Yes, sir.
That'll be mine, Judge.
All right. Barry, do you want a formal arraignment?
No, we'll waive a formal reading of the indictment and enter not guilty plea on all charges.
Very good. Now, I'm going to put him down for a not guilty plea. I might try to turn this one around just a tad bit quicker than we normally do. My recollection, and I can't recall for sure, but my recollection strongly is rattling around in my head there that Mr. Furlong had maybe a Tennessee, a warrant out of Tennessee that's hanging him up. Am I wrong about that?
That's correct, Judge.
So,
Yes.
this case is going to have to get straightened out so that case can get addressed, I think.
Yeah, I've done signed my extradition papers. I had 30 days to come get me. It's still been 30 days.
Yeah, but that 30 days can turn into longer if they can't come get you because you've got a hold on you out of another case.
What am I facing here? Like, how much time?
Well, Mr. Furlong, I don't know the answer to that other than in broad terms.
I might just owe some money and some time.
Fleeing or evading police first degree is a Class D felony. A Class D felony is punishable by 1 to 5 years of incarceration. Everything else is relatively minor compared to that. So, that would be the one that would cause you the most trouble. Mr. Barry, let's do a pretrial on April 26th at 1 o'clock, okay?
Oh, okay, Judge, that'll work.
And then, I don't know, it might be something that can get squared away so that he can get his other issues addressed. If it isn't, it isn't.
What about my bond, the reducement on my bond?
Well, your bond right now is 2,500 cash. And that's where, that's where I'm gonna leave it until I see you again.
All right, Tim.
All right?
Yeah.
All right, thank you.
Yep.
Michael Herzog. Thank you. All right, Mr. Herzog, how are you?
Very well. How are you today, Your Honor?
Well, I'm doing all right. Let us see here. Looks like we've got some signed papers, am I right?
Yes, sir.
All right. Bear with me for just a minute here and let me get up here where I can see the two of us. Can you raise your right hand, please? Do you swear to tell me the truth, so help you God?
I do.
All right, Mr. Herzog.
Yes, sir.
I'm gonna show you the paperwork that I've got. Did you all send me a motion in or a guilty plea that I have somehow misplaced?
Should be one in there, Judge. He signed one.
I don't have it. I've got his signature on the plea offer. If you all think there's one out there, then I'm just going to go ahead and proceed, and then you all can see if we can track that down and send that in. Okay.
Yeah, there is one out there. I'm
All right.
positive
All right.
of that.
It's possible that it just didn't
Yeah, okay,
get faxed in or whatever, but you can e-file it or something if you can find it.
okay.
All right, Mr. Herzog, do you understand that you have the right not to incriminate yourself, and you waive that right if you plead guilty?
I do.
Do you understand that you have the right to a speedy and public trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt, which you waive if you plead guilty?
I do.
Do you understand that you have the right to confront and cross-examine the people that testify against you, and the right to put evidence on in your own defense, and you waive those rights if you plead guilty?
I do.
And finally, do you understand that you have a right to appeal the outcome of your case to a higher court, and that right is waived if you plead guilty?
Yes, I'm aware of that, Your Honor.
All right, thank you. Mr. Herzog, do you feel like you're under the influence of anything today?
No, sir.
Is your judgment impaired whatsoever?
Not a bit.
Have you had all the time you need to discuss this case with your attorney and to think about how to proceed?
I have.
All right. Looking at your plea offer, my question to you right now is going to be, does this document here have your signature on it?
It does.
All right. And just so you know, this is the front page. Does this
Yep.
look familiar to you?
It does.
All right. Did you have all the time you needed to go over that?
Yeah, I read the whole thing thoroughly, and
All right. And you also signed, as Mr. Berry told me, a motion to enter a guilty plea. Did you have all the time you needed to go over that as well?
yes, sir.
All right. In this case, the Commonwealth is recommending the following. Count 1, possession of a controlled substance, first degree, third or subsequent offense. That is a Class D felony. The Commonwealth agrees to recommend a 2-year sentence on a guilty plea. Count 2, possession of drug paraphernalia, a Class A misdemeanor. The Commonwealth agrees to recommend a sentence of 12 months on a guilty plea. The Commonwealth agrees to recommend supervised probation of that sentence on condition that you enter and complete a residential treatment program at Park Place, including any recommended aftercare, that you maintain employment, and that you follow the terms and conditions of probation. it is also my understanding, even though it's not written in here, just to bring up that you have two motions to revoke probation. Well, it's one motion in two cases, and that the Commonwealth agrees to resolve those motions in the same way with you doing this Park Place, right?
Yes. Yes.
All
sir.
right. All right. Other than what I just talked to you about, has anyone promised you anything to try to get you to plead guilty?
No.
Has anybody threatened you to try to make you plead guilty against your will?
No.
Mr. Herzog, are you telling me here today that voluntarily and of your own free will, you acknowledge on February 19th, 2021, you knowingly and unlawfully possessed a Schedule II controlled substance, which was methamphetamine?
Yes, Your Honor.
Are you also acknowledging that at that same time and place, you used or possessed with the intent to use drug paraphernalia?
Yes, Your Honor.
Mr. Herzog, I'm going to accept your guilty plea today as having been entered into freely, knowingly, intelligently, and voluntarily with the advice of counsel. I am going to, on your two pending probation cases, we will enter an order that says, in lieu of revocation, you are to enter in complete residential treatment at Park Place and aftercare, provide proof of employment to your, and I don't have any doubt that you've been working, so it's just a matter of getting the proof in there, and that you comply with all the terms and conditions of your probation, which was already part of your order. Okay.
Okay.
Yeah, let's talk about what we know. What do we know, Mr. Berry, if anything, about what the future holds?
Judge, I think Bethany Bethany, are you on here? I thought she was. I keep thinking she's on these calls and then she's not.
I'm here.
Oh, okay.
I have made the referral. I'm just waiting on the bed date. I'll send it to Chrissy as soon as I get it.
Okay.
Super. Mr. Herzog, does that address your question or did you have something else?
I did have another question, Your Honor. I was wondering if it would be possible if I can get out a day or two before my bed date so that I can get my license for this Park Place, and also I need license so I can do my taxes. Not license, but ID.
Yeah. Let me tell you what I'm going to do. And this is what this is just kind of a common way to handle that. Since I don't know what your bed date is, I don't want to say for sure when you're going to be getting out, but if I get some notice, which they give me as much notice as they can, don't get me wrong. I mean, it's just something, but I mean, as long as I get enough notice to get you on out where you can take care of some of these housekeeping matters, to make it easier on you, I'll do that. Okay.
Okay. Excellent. Thank you, Your Honor.
The only thing is, and I'm not trying to mislead you. I mean, every now and then they'll tell me on a Friday that somebody's got a bed date on a Monday. And there wouldn't, I could still let you out, but there wouldn't be much time to get a driver's license, or whatever, because it would be a weekend. But usually that doesn't happen. I mean, usually it's, they may tell me on a Wednesday, you got a bed date on a Friday or something like that,
Okay. Okay.
Okay.
All right. I want to thank you all very much.
All right. Hey, hang in there. Good luck. Okay.
All right. Thanks, Your Honor.
We got Mr. Hicks next.
Is John listening to music?
Shine on, you crazy diamond. I don't know who it was, but
it was my fault.
All right. Are we anywhere here, or what's our plan?
I'm sorry, Judge, this Jay Hicks? I can't.
Yes, sir.
Okay, we submitted the paperwork on him on all 4 cases.
All right. In what format that was submitted? Because it's not in my file, which doesn't mean that you hadn't faxed something.
I believe it was emailed to Chrissy, if I'm not mistaken.
Oh,
I
okay.
had never gotten that, Greg. I didn't send anything.
Oh, I'm sorry. I thought I laid it on your desk.
No, I only had Michael Herzog's. I'm sorry.
It's all right. Well, how do you want to, I mean, we can do it at 1 o'clock if you want to, if that gives you enough time to get what you need.
It should. All it is emailing it in. Everything's signed and ready to go.
Okay. Or I mean, if you get it before we wrap up this morning, we'll just call him back up here and do it this morning.
I can run to the office really quick and get that sent. I'll be back with it.
We'll just send it to Chrissy Parker. Okay.
Okay.
All right. All right. Good deal. Mr. Hicks, we'll come back to you. All right. All right. Jerry Pettigo. All right, Mr. Pettigo, you're here because of an indictment that came down back a week or so ago, 2 weeks ago. And it charges you with the offense of possession of a controlled substance, first degree, third or subsequent offense, and possession of drug paraphernalia. Do I need to appoint a lawyer for you?
I thought we talked about running this in with my time I got going. We'll go ahead and get it over with. I got 3 years now.
Yeah, I mean, maybe there was that conversation, but you hadn't been indicted back then. So,
yeah.
I mean, I just have to arraign you and then we have to, yeah. So, but part of the arraignment is to see if I need to appoint a lawyer, and I think I probably do.
Yes, sir.
All right.
Yep.
That'll be Zanda, Judge.
All right. So, Miss Myers. And yeah, go ahead.
Is this a new indictment? I apologize. I missed it at first.
Yeah. This is Mr. Pettigo is in custody right now. He's a state inmate. He was on, I don't know, were you on probation, Jerry? Was that what it was?
Yeah.
And then it got revoked, and this was part of, I think, what got it revoked. And then the indictment has just happened. So he's, I'm going to go ahead and just arraign him and appoint counsel, and maybe we'll try to come back in a month or so and see if y'all have enough time to get the thing worked out.
That'll be fine, Your Honor.
I mean, he was thinking that there was some discussion about it back then, and honestly, I can't recall.
That's what we talked about then. You said something about maybe we just put it off for a while and we'll get it all run together and just keep on trucking. I might just been your fast way to just get me out of the way, but
I might have just been tired of talking to you.
Probably so. Before you quit this time, I got a question for you.
All right, go ahead.
On the same matter, on the time I'm doing now, I got an ankle bracelet way back when first, and I got driving on suspended again, and they evaluated me on my bracelet, give me 180 days, and you get me back out. You said I could get that jail credit, but I can't get it unless it's in paper form saying I can get it. You're the only one can give me that. I hate to bother you, but I really got to use that other 180 days up here.
You were on house arrest, right?
Ankle bracelet. How's it working?
Yeah. Miss Myers, and just so you know, because you weren't representing him on that, his the underlying charge where he got the revocation was it was a 4th DUI, wasn't it, Jerry?
Driving on suspended, John, a 3rd.
Oh, driving on a DUI suspended.
Yes.
Yeah. And I think he's I think that we started out allowing him, he entered a plea, and we started out allowing him to do his sentence on a house arrest, and then that's what ended up getting revoked. And what I'll have to look into that and see. Obviously, anything that you did on house arrest, the law says you get credit for that. They don't need an order from me, but if they want one, I can do one. I mean, if you're on house arrest, if you're on house arrest, you get credit, you know.
Yeah, right.
But what I'll do is I don't know who's on here from probation, but I will ask them to look at your calculation and make sure that you got credit. a lot of times they can't tell, maybe, you know, it might be that they can't tell whether you were on house ankle monitor or not. So you might not have gotten that credit and that, you know, nobody's trying to cheat you out any credit. So I'll make sure that we do what we need to do. Okay.
Yep.
All right. So I'm gonna, you're gonna enter a not guilty plea.
Yes, sir.
On this case. I'm appointing counsel for you. We'll put you on for a pretrial conference on April 26th at 1 o'clock. Okay.
Yes, sir.
All right.
Appreciate you.
All right. Thank you.
Thank you. Hey, when will I hear something on about that jail credit stuff? I wrote you, DOC, prosecuting attorney. I wrote a lawyer. I don't know which one it was, so I wrote all three of them. I've never heard nothing.
Yeah.
Yeah.
Well, I mean, I'll look at it and say, I'll send something to probation and parole and just tell them to make sure they calculate that in. Okay.
All right, John. Thank you,
All
sir.
right.
Appreciate you.
All right. Let's see. Brian Perry. All right. Ms. Myers, are you on this one too?
I am, Your Honor.
All right, very good. Mr. Perry has a F case that it's my understanding that you all have come to an agreement on. Am I right?
Correct.
And is that also resolving his, well, we have a motion to revoke probation? Is that what it is? Yeah.
Yes, Your Honor. We've reached an agreement on everything.
Okay. I'm just kind of thinking out loud here. So I apologize. I'm reading through the file and can I give you that? Brian Perry's file. All right, Mr. Perry. Do you think you've got an agreement?
Yes, sir, I do.
All right. Will you raise your right hand, please? Do you swear to tell me the truth, so help you God?
Yes, I do.
Mr. Perry, do you feel like you're under the influence of anything today?
No, sir.
Is your judgment impaired for any reason today?
I'm good, sir.
All right. Have you had adequate time to discuss
Yes, sir, I have.
all of this with your attorney?
Yep.
All right.
Hey.
All right. And in the file here, I have this document that is
Yep, I
entitled.
got it. Yep.
All right. That looks familiar to you?
I got it in room.
All right, hold on. All right, there we go. Now, Mr. Perry, is this your signature?
Yes, sir, it is.
Did you read over this before you signed it?
Yes, I did, sir.
Did you get the chance to ask your attorney questions?
Yep.
All right, are you satisfied that you got the chance to ask her all the questions you had?
Yes, I did, sir.
And did you understand this document when you signed it?
Yes, I did, sir.
All right, thank you. The Commonwealth has made a plea offer. It's on this document, okay? Does that look familiar?
Yes, sir, it does.
And the
I
signature
signed
page?
it. Yep. Yep, that's
All right.
it.
Did you look over that one and talk to your attorney about it as well?
Yes, man, I talk about everything in papers I signed.
All right, good. We also have, last but not least, this document that is entitled a waiver, okay? See
Yep.
that?
Yep.
All right. And if I go back here to the third page.
Yes, sir.
Signature. All right. So I'd ask you the same questions about that. Did you get the chance to read it?
Yes, I it bit up, sir.
Talk to your lawyer?
Yep.
Did you understand it when you signed it?
Yes, sir.
Mr. Perry, do you realize that you have the right not to incriminate yourself? And if you plead guilty, you waive that right.
Yes, sir.
All right. Has anybody, you do not have to plead guilty. Has anybody threatened you to try to get you to plead guilty?
Does it look like somebody threatened me, sir? You know better than that.
Well, I mean, I have to ask.
No, sir, ain't nobody threatened me.
Has anybody, all right. Do you understand that you have the right to a jury trial? And if the Commonwealth, if we have a trial, the Commonwealth has to prove guilt beyond a reasonable doubt.
Yes,
If you
sir.
plead guilty, you waive that right. Do you understand?
Yes, sir, I do.
All right. You have the right to confront and cross-examine the people that give evidence against you, as well as the right to put evidence on in your own defense. Do you understand that you waive those rights by pleading guilty?
Yes, sir.
All right. last but not least, you have the right to appeal the outcome of your case to a higher court, and you waive that if you plead guilty. Do you understand?
Yes, I do.
Very good. Mr. Perry, in this case, the Commonwealth has made the following offer to you. Count 1 is possession of a controlled substance, first degree, second offense. On a plea of guilty, the Commonwealth would recommend a sentence of 2 years. You also have count 2, assault, 4th degree, domestic related minor injury. On a plea of guilty, the Commonwealth recommends a 12-month sentence. Count 3, drug paraphernalia. On a plea of guilty, the Commonwealth recommends a 12-month sentence. All of those sentences would run concurrently for a total of 2 years. The Commonwealth agrees to probate that sentence for a period of 3 years on the condition that you get an assessment and comply with any results of that assessment as may pertain to treatment. Has there already been an assessment? Is that right?
There has been, yes.
All right. So it looks like the assessment has already occurred and that the recommendation is long-term residential treatment. So we would go ahead and say that part of your probation will be that you enter and complete long-term residential treatment and any aftercare that comes with it. Do you understand that?
Yes, sir.
All
Where
right.
will I go?
Don't know the answer to that. I mean, I'm not trying to hide the ball on you. I just don't know. You know, you'll probably go to the first available location that has a bed. Okay.
All righty.
All right.
When I do it, go to rehab, can I get out like an hour or a day before like I did last time you sent me to rehab?
Well, that depends because I don't know where you're going to be going. And some of those, you know, you either get transported by the authorities or they come and get you. And if that's the case, then I won't be able to do that. So
Yeah.
I'll just have to wait and see what happens and where you're going and how you're getting there.
All right. Thank you.
Okay. Mr. Perry, we're not done yet. All right. So do you, has anybody other than the Commonwealth making the promises that I just read to you, has anybody promised you anything to try to get you to plead guilty?
No, sir.
All right. Are you pleading guilty because you acknowledge that on March the 16th, 2021 in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine,
Yes, sir.
having a prior conviction for possession of methamphetamine?
Yes, sir.
All right. Are you also, I mean, or for possession of a controlled substance? I don't remember if it was
I
methamphetamine.
get you down and ask a question.
What?
Up at Crown Recovery Center up in outside of Eat Town. They said they didn't get me a bed up there.
Okay.
He had already been assessed by probation and parole, according to Mr. Gardner, and they had determined that he needed an RKC bed. His family had arranged for him to go to Crown Center, but we had discussed that the SDL that had assessed him found that he was more appropriate for an RKC.
Yeah, if they, I mean, whatever the assessment comes out to, you know, whatever type of
What's that
facility
kind
it
of
comes
at?
out to, that's what you'll have to do. Huh?
What kind of rehab is that? What you talking about?
RKC, it's a program. It's Recovery Centers of Kentucky.
All right.
A long-term treatment. There's a lot of different rehabs qualify for it. They'll try to probably put you in on the first bed that they have available. So I can't tell you exactly where it's going to be or anything like that. They put it through probation and parole and locate that for you.
All right,
Yeah.
Thank you.
All right, Mr. Perry, are you also admitting to me that on March 16th, 2021, you are in possession of drug paraphernalia?
Yes, sir, I was.
Are you admitting to me that at that same time you committed the offense of assault in the 4th degree when you intentionally or wantonly caused physical injury to Brittany Brown?
Yep.
All right. And that is charged as a domestic assault. So Brittany Brown would have to be somebody that you're either related to or that you lived with currently or formerly or had a child with. Okay.
Yes, sir. Yeah.
All right. The only thing I want to warn you about, Mr. Perry, is that a domestic violence assault is what we call enhanceable. So, you know, you could get the same type of charge in the future and it could be a felony 3 in a 5-year period of time
Yeah, I
becomes
know.
a felony, right?
You don't worry about that. I know.
I just have to tell you, okay?
Yeah, I know.
All right. So in 19 CR 319, that was where the Commonwealth had filed a motion to revoke your probation. And Mr. Gardner, in lieu of revocation, he's going to enter and complete this treatment consistent with this plea we just did. Is that right?
That's correct, Your Honor.
All right, Mr. Perry. Here's what we'll do. You just sit tight until we find out where you're going to be, and then we'll make it happen, okay?
Thank you, sir.
Listen, hang in there and get this done, okay?
Hey, I'm going all the way through this time.
All right, buddy.
Crap.
All right. Yeah, we'll see you.
See you.
I believe that our witness is back for Mr. Roy. Hart County Jail's on here with Mr. Roy, and we probably ought to go ahead and do that one.
Right,
Because I
Judge.
told them I'd try to get to them as soon as I could when they got in. All right. Who represents Mr. Roy?
Talk about Mr. Coy, Judge.
Mr. Coy. I'm sorry. Yeah, I keep.
Yes,
I
that's
apologize.
mine.
All right. Yeah, that's my bad. I'm sorry. Mr. Coy. All right. Mr. Richardson, who are you calling, sir?
Deputy Skaggs from Edmonson County Sheriff's Office.
All right. Deputy Skaggs is back with us. Sir, can you raise your right hand, please? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. Proceed, Mr. Richardson.
Okay, can you state your name for the record?
My name's Matt Skaggs. I'm employed at the Sheriff's Office as a deputy in Emmons County.
Okay. On November the 30th of 2020, did you arrest Brandon Coy?
I did.
Can you tell the court what led to that arrest?
Yes, on 11/30/2020, myself and other officers were dispatched to 1103 Silent Grove Church Road within the county of Edmonson for someone in the a caller called in and reported that someone was actively attempting to steal a vehicle from that property. The sheriff, Deputy Meredith, and I all responded from different locations. I was the first on scene. To give you kind of a quick rundown of the scene, Judge, this is a semi-abandoned property. A house had been on the property before and had burnt down. There's still like a garage/barn storage area that's separate, and there's vehicles there parked around that. And in the past year or so, there's been vehicles stolen from this property. There's no trespassing signs posted as well, and it's an area that we know of that people have showed up and stolen different property from. When I arrived on scene, there was a pickup truck that was running, and attached to it was a trailer that had a BMW on the trailer. The pickup truck door on the driver's side was open. The vehicle was unoccupied. Went up to the vehicle, removed the keys, or shut the vehicle off. Yeah, and removed the keys. And around that time, Deputy Meredith and Sheriff Dole arrived on scene as well. And two individuals walked around from behind what we'll call a barn. And that ended up being Mr. Brandon Coy and Sydney Sawyer. Spoke with them. They admitted that they had arrived there in that pickup truck. We ended up separating them, speaking to them separately. They both informed us about another man that had been there with them that had fled the scene when he saw the blue lights of the police nearing. Deputy Jones arrived on scene as well. We searched, were unable to locate another man. And in the pickup truck, Jones described different things that he'd found to me, and that Mr. Coy and Miss Sawyer both admitted that they had belongings in this pickup truck. I spoke to the landowner, Charles Thompson. He informed me that he'd given no one permission to be on that property. No one was to be on that property. And that the vehicle, the BMW, was supposed to be on the property and that they didn't even have a working key to it because the working key had burned up in the fire. And that he had spoke to the actual owner and a relative of his, and Anthony Petty. And Anthony had reported to him that he had not given anybody permission to take the vehicle, move the vehicle, wasn't selling, giving it away, anything like that. Neither one of these parties knew Mr. Coy or Miss Sawyer. Also, that the vehicle, the BMW, had been damaged on the inside, so it was able to be loaded up onto the trailer. It wasn't prior loaded up onto the trailer. And from what Mr. Coy had said, what had happened when they were leaving, the truck had got stuck in the mud, and that's why they hadn't been able to fully leave the scene before the police arrived. Miss Cindy and Mr. Sawyer's stories didn't line up exactly. They gave different details on where they'd been when they'd gotten there and the reasons for being there. Miss Sawyer stated that Coy was there to buy the truck, the BMW, the car. And Mr. Coy stated that he was just there helping a man load it up. They gave me a name at that time, which later ended up not being the name of that supposed third individual. We'll go ahead and note that later that day or into the next, pickup truck near that area had been stolen and was believed to be stolen by that third person. Days later, Mr. Coy stated that he wasn't there to ever steal the truck, that he was there to help, the BMW, he was there to help move it, and he didn't know that it was stolen. Whether or not that's true, I don't know. He did call days later and report where the stolen pickup truck was, and said that a man by the name of Mike, later identified by Michael Rust, was in possession of that stolen pickup truck, and that's who originally was stealing the BMW. From the information I've read and been informed by Bowling Green City Police, they arrived at the address and ended up locating the gentleman that Coy had talked about, the stolen pickup truck, and that Mr. Michael Rust did flee from them and originally wouldn't identify himself once he brought into custody.
Pass the witness, Judge.
Yeah, Deputy, so Mr. Coy helped find the stolen pickup, is that correct?
He did.
Okay. Okay. The charges that were filed against him, are they in district court or circuit?
It's been presented to grand jury. I'm unsure if they've done a return. I've been out for a couple of weeks on COVID restrictions.
Okay. I think that's all the questions I would have, Judge, for the detective. For the deputy.
All right. Mr. Richardson, do you have any other questions of this witness?
I don't have any more for Deputy Skaggs.
All right. Deputy Skaggs, thank you for your time. You are free to go, okay?
Thank you, Judge. Have a good day.
All right. You too. Mr. Richardson, do you want to put any additional proof on besides that testimony?
I'd like to call Officer Alexander.
All right. Jason, are you on here?
Yes, I am, Your Honor.
Can't find you. Where are you?
It's showing them. It's showing them on.
Well, I can hear you. Oh, there you are. Okay. Raise your right hand, please. Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor. Yes, sir.
Okay, go ahead, please.
Can you state your name for the record?
Jason Alexander.
And you're with probation and parole out of Glasgow?
Yes, I am.
Were you monitoring a Brandon Coy in a Edmonson County case for probation?
Yes, I am. Okay. He was, yes, sir, I sure am. He was assigned to my caseload on December 16, 2019, and I've supervised him ever since. I had to do a violation report to Edmonson County. He was released from the Hart County Jail on December 8th, and he failed to call or report. I sent a letter to the address that he had put on his bond conditions for Barron County, 278 Oak Tree Road, Smiths Grove. The address was listed on the bond, and I directed him to report immediately. on 1/4/2021. He had failed to report, and then I had to get an absconding warrant. The mail came back undeliverable, and that's what. And so I had to get a absconding warrant issued, and he was picked up, and there's a pending court date for Edmonson County for a revocation hearing.
That's all the questions I had, Judge.
Mr. Berry?
I don't have any questions for Mr. Alexander, Judge.
Okay, very good. Mr. Richardson, anything else of this witness?
No, sir.
Of any other witness?
No, sir. That's it for the Commonwealth.
All right, Mr. Berry?
Judge, I'd just like to make an argument on this.
All right, fair enough. Go ahead.
The charge over in Edmonson County, I think, is a long way from being resolved here. I know just an arrest can get you revoked, but Mr. Coy actually helped the police in this to find this pickup truck or who may have taken it in this scenario. I'm not sure, and also the deputy's not even certain if this case has been indicted or if it's still pending grand jury. It may not even get indicted. I don't know. We would ask the court I believe Brandon's been in jail now for about 2 months over this, or maybe a little longer than that. We would ask the court to not revoke his bond on this matter, to give him a sanction for the time he's already done on it and allow him back out on his bond. I believe, and the court's well aware of it, and we all are entitled to the presumption of innocence on this case out of Edmonson County. We would ask the court to not revoke him on his bond, to simply to give him a sanction and allow him back out on it.
All right, Mr. Richardson.
Well, Judge, for the first part of it, the reason why I called Officer Alexander for violations that occurred in another county, he was being monitored. Edmonson County had not moved on it, and the bond condition here says that he's to obey any other applicable court order. And he was violating his conditions of probation in another county. He could not be located. And I think it's also something to point out that Officer Alexander had filed that report based on his not reporting in December, which means he was released from jail on, based in part on the new charge he got out of that Deputy Skaggs had testified to, and had not reported it to his probation officer. The second part of the motion, when I supplemented it, we didn't even realize that he had these new charges out of the other county. And Mr. Berry's saying that, well, he was trying to help out. I think it's equally arguable that he's trying to basically throw the case off and divert attention to somebody else. It seems like he was with other individuals who were trying to steal multiple vehicles. True, he's innocent until proven guilty, but I think there's a lot of troubling issues here. This is a Class C felony that he's facing right now in our court, and he has a co-defendant. We need to get moving on this. And I think him being out on bond and him having these other charges is concerning. And I think his bond should be revoked based on this new information.
Well, let me tell you, he, as far as I can tell, he did get indicted in Edmonson County. He had never had a hearing on his probation revocation, or at least they haven't revoked him on his probation. He says he's got a hearing set for April the 19th. So what I am going to do is, Mr. Berry, is, for our purposes, I'm going to put him on for a pretrial conference. We'll do April the 26th. I think, Jason can tell me, but I'm fairly certain that he's got, he's got that probation revocation in Edmonson County now pending. So, I don't think that what I do is going to make any difference one way or the other. But I do think that based upon the violations that I've heard the testimony about, I think it's appropriate to enter an order of revoke bond, at least till we come back, and then we'll figure out what happens. we'll see. He should have both of his other things, at least should be able to get to court on those, figure out what's going to happen on those. And then we'll, maybe we'll have something worked out in our case. Maybe we won't. If we don't, then, we'll figure out how we're going to go from there. And, if we need to talk about his bond at that stage, we can. Okay.
Okay.
I'll keep everybody posted on what goes on in Edmonson County when I find out.
All right. Good deal. So pretrial conference 4/26, 1 o'clock. All right. Thank you.
Thank you.
What that case about? Okay. All right. I believe that's Hart County. It's everybody I have in Hart County, isn't it? Super.
Judge, I think on J Hicks, we're I think, emailed those to Chrissy.
Okay. So we need to send him another invite to let him back in, but he wants to be in. Mr. Bell, are you on here?
Yes, sir, I am.
Do you, she doesn't have that stuff yet, so we'll talk about Mr. Wilson before we get, while she's getting that stuff brought in.
Oh, thank you, Judge. I think the only thing we have on Mr. Wilson is an arraignment and then issue of his bond being revoked over some situations with his ankle monitor.
Yeah, before we get into that, Mr. Berry, is Mr. Hicks entering an agreement in 3 cases or 4?
I can't remember, Judge. I'm thinking there were 4.
It's all 4. I just sent the last one to KP.
Okay, very good. I was going to say, they told me they had 3 cases worth. Now they got 4 cases worth. Okay.
Yes.
Thank you, Chrissy. All right. Yeah, Mr. Noah Wilson.
Judge, I had filed a motion to revoke his bond based on the issues Mr. Bell was alluding to.
Right. Mr. Mr. Wilson is with us for, like you said, an arraignment's part of it.
And we would acknowledge receipt of the indictment, acknowledge Mr. Wilson being the person named that indictment, waive formal reading, enter a plea of not guilty, Your Honor, and ask for a pretrial conference. And ask to reserve the right to file all motions pertaining to the case, Judge.
Yes, sir. So, yeah, here's what we've got going on with the motion to revoke bond. Mr. Wilson was out on the monitor. He has been out a little while, but I did get a call from Miss Atkins that basically that monitor was staying charged less often than it was running out of charge. And I mean, an uncharged ankle monitor is not any monitor at all. So he basically was not being monitored, and that's why I did what I did.
Your Honor, I understand completely, and I hope Mr. Wilson has learned his lesson concerning that. I will ask the court, Your Honor, if it would consider a sanction against Mr. Wilson. And also, Your Honor, as far as the ankle monitor, I know a lot of times those are placed upon there for drug cases and things of that situation. Of course, Mr. Wilson's is basically an assault case, assault third. If the court feels more comfortable and the only way to get out is an ankle monitor, I think we're all good with that, Judge. I just would like to ask the court to consider, maybe due to the charges, that an ankle monitor is no longer necessary.
All right. Well, first off, let's do this. First off, there is he's been arraigned and he's entered a plea of not guilty. and we will schedule this for a pretrial conference. Before I decide what we're going to do about the motion to revoke, I'll let Mr. Richardson address whatever it is that you wanted to address, because I mean, we may need to set it for a hearing and we may not.
Well, I've got concerns. Mr. Bell had contacted me early on in this case, and I was very reluctant to, but I agreed to do an ankle monitor. I've got concerns at this point. If he's not following the rules with the ankle monitor, this isn't, as Mr. Bell said, an assault third. He doesn't have much of a record, or he doesn't have, I don't think he has any record, but the actions he took, or he's accused of doing in this case, are concerning. I would not want the court I'd ask the court not to sanction him. I think we should set a hearing and hear from Ms. Atkins before you decided to make a decision on this. And also, my position at this point is, I don't think ankle monitor is going to work, and I'm against it at this point.
Okay, Mr. Bell, go ahead.
I mean, I think we have heard from Miss Atkinson, because she brought forth this information, and what we've got is a situation of not charging a monitor. Mr. Wilson, as Mr. Richardson said, has no criminal history whatsoever, none, zero, blank. And on top of that, Judge, he's not got out here and committed another crime. He's not got out here and hurt anyone or bothered anyone, nor has he got out here and got a dirty drug test or anything like that. I mean, it's not, I understand it's a problem, and I don't mean to make light of it at all, but I will say, Judge, that, being doing this for 23 or 2 or whatever years it's been, this is not the most serious infraction I've ever seen, and I hope that we can remedy it somehow without, keeping Mr. Wilson detained.
Well, I mean, I didn't do anything lightly, because I talked to her first just to make sure that everybody is aware. And if despite, I mean, she doesn't even do reports on people for something like that until she's at her wit's end. And as witnessed by the fact that she let this thing run down multiple times before she talked. And frankly, I think her testimony would be that he just wasn't paying any attention. I mean, she didn't tell me this under oath, so I can't say I know what her testimony is going to be, but I think what her testimony is going to be is that he was basically just thumbing his nose at her because he didn't think she was going to do anything about it. And that is not what the ankle monitor is there for, is to let it run down and just have it hanging on your ankle,
Yes, Judge, I'm willing to rely, if you've talked to Ms. Atkins about it and you feel like you would be okay with him going back on ankle monitor, I won't, stand too much in the way, but I did want to put it out there for Mr. Wilson that how this case goes is going to really be determined by how he acts from this point forward.
Yeah, I understand. Well, listen, this thing has been pending now, through nobody, I'm not blaming anybody, but it's been pending now from where the original incident occurred for months and months and months. And, he's been out of custody during that, virtually all of that time, because of the ankle monitor. And, that was another reason that it seemed like to me that, there needs to be some immediacy to these things, especially for a young person that had never been in trouble before, as far as I could tell. They need to know that sitting there looking at 3 felonies of assaulting peace officers is serious stuff. It's not, it's not anybody making too much noise with their loud muffler. You know what I mean? Or whatever it is that you want to relate it to. It's serious stuff. And so I felt like he needed to get in here and have, hear this from me and hear this from the prosecutor, and also hear it from the attorney that your family's gone out and spent money on. He's not a miracle worker, and he ain't gonna keep pulling your irons out of the fire, your butt out of the fire every time you mess up. So what you need to do is listen to what people are telling you. The way to get the ankle monitor off is not to keep having enough violations to have me put you in jail and then ask me to take it off while you're in there. That's I mean, the way to get it off is to do everything you're supposed to do and follow all the rules. And then maybe you earn the right to get a little bit more accommodation out of me, and I can take it off. But I'm not going to take it off. I am going to, what Miss Atkins felt like an appropriate thing to do when I talked to her was that, you needed to know that this was serious and not just a bunch of people playing. Man, everywhere I go, I'm getting ready to say something I'm supposed to say. Not just a bunch of people fooling around. I mean, this is what everybody up here does for a living, and we didn't take these jobs just so you could fool around and ignore everybody. All right.
Your Honor,
can you hear me? No, we're not talking about what happened. We're talking about what's getting ready to happen.
Okay.
All right. We're not taking any evidence. I'm not going to take any testimony or anything, because what I'm going to do is I'm going to give you a sanction. And I probably wouldn't do it if I could have you hearing next week, just to be honest. But since we're not having court next week, I won't make you wait another 2 weeks to get back in front of me. But Mr. Bell, what I'm going to do, he's pled not guilty. I'm going to give him a pretrial conference on May the 24th at 1:00. I'm giving him a 10-day sanction on his failure to comply with his bond conditions. I think he got arrested about a week ago, somewhere in that ballpark. He's going to have to get the ankle monitor put back on to get back out. When he gets that ankle monitor back on, we'll be starting over from where we were, trying to do better this time. Okay?
Yes, sir.
And you need to, Mr. Wilson, stay in contact with your attorney, because now that you've been arraigned, it's time to get moving on this case and figure out where we're going to go. Okay?
Yes, sir.
All right.
Yes, sir.
Mr. Bell, anything else? Call him when you get out.
Your Honor, as far as the date, and the 24th, is that a Tuesday, or that's not getting crossways with the new changes in district court, is it, Judge? Because they backed everything up from 2:30 to 1:00. In accordance with.
I don't know what you're asking. I'm not sure what you're asking me.
Never mind, Judge. That's a Monday. I'm good.
Yeah, it's a Monday.
Judge Pendleton had called and said that we needed to do some things because it was jamming up the court system so bad. And it was. And I just want to make sure I wasn't scheduling something wrong in that situation. But I think that's just Tuesdays and Thursdays.
It's a work in progress.
I understand, Judge. Thank you.
And I do appreciate, I know, I'm not trying to be a smart aleck. I mean, I know he's trying to make some changes so that we can kind of get this stuff to dovetail a little better than it has been. And that's what we're trying to do. But I mean, we're both just winging it.
I understand.
If it happens. Yeah.
And that's right. Mr. Wilson, have you got a issue or something?
I was just saying, I apologize. My monitor died while I was at work. I've been employed since the incident happened, and it was my fault that it didn't get charged. So we'll be working to make this better. Thank you, Judge Alexander, and thank you, Johnny Bell.
All right. Good luck.
Thank you, Judge. You have a good day.
All right.
All right. Michael Riley. All right, Mr. Riley. Can you you are Michael L. Riley?
Yes, sir.
All right. And Mr. Riley, what is your address?
I don't currently have one right now.
Okay. I need to appoint an attorney for you. Is that right?
Yes, sir.
Okay. Can I, Mr. Barry will appoint someone from your all's group.
Okay, Judge. That'll be me, Judge.
Okay. All right, Mr. Riley, you're charged here today with one count of fleeing or evading in the first degree. and one count of theft by unlawful taking 500 or more. Both of those are Class D felony charges. I'm appointing counsel to represent you. Mr. Berry, do you all want to waive a more formal arraignment?
We would, Judge, and enter not guilty plea to all charges.
Okay. Going to put Mr. Riley down here as a not guilty plea. We'll set this for a pretrial conference. That pretrial conference can be, you want to look at May the 17th?
Okay.
So we'll try to do May the 17th at 1 o'clock.
Okay, Judge, I don't know Mr. Riley's bond situation here. If there's any holds on him from anything else, or if this is the only thing that he's dealing with right now.
He does have a pending felony in Warren County, Judge.
Yeah, I think at one time at least they had some kind of hold on him over there, but of course they may have been able to address it with him since he's been in custody here. I don't know the status of it.
Judge, I also wanted to point out that his address is out of Tennessee, so I don't know any pretrial risk assessment. Obviously, is not going to have, any ability to look at if he has anything out of Tennessee. So I'd ask the court to consider that.
Yeah, I mean, I think the pretrial risk assessment in this case is useless is probably too strong a word, but it has very limited utility because of that. And I just asked him and he said he didn't have a home base anymore. So that's also kind of skews the, yeah, he's got a $10,000 cash bond in Warren County, is what the CourtNet says. So, I mean, this is 2 Class D felonies and the bond is 5,000 cash. I think that's probably under the circumstances that we've laid out here. I think that's fair. Mr. Riley, in the event that bond and the Warren County bond are not both made, I will be seeing you over in May, and I'm appointing counsel for you. Okay?
Yes, sir.
All right. Thank you. I just didn't want you all to not hurt. I don't have anything to write this for. Or she'll be doing an arraignment order. Let's see. Jason Taylor. All right, Mr. Taylor, it looks like maybe you guys have come to an agreement in your case. Is that right?
Yes, sir.
All right. Will you raise your right hand, please? You swear to tell me the truth, so help you God.
I do.
All right. Mr. Taylor. Here we go. I have here a motion to enter a guilty plea. Does that look like something you've seen before?
Yes, sir.
On the second page, there is a signature page. Is that your signature?
Yes, sir.
All right. I have the Commonwealth's written offer on a plea of guilty. Does that look familiar to you?
Yes, sir.
And on the second page, does it have your signature?
Yes, sir.
Now, did you read both of these before you signed them?
I did.
Are you comfortable that you understand what you have signed?
I am.
Mr. Taylor, are you comfortable with the amount of time you have had to discuss this case with your attorney?
I am.
All right. Do you feel like you're under the influence of anything today?
Nope.
Do you feel like your judgment is impaired for any reason today?
Nope.
All right. Mr. Taylor, have you been threatened by anyone to try to get you to plead guilty?
Nope.
You understand that if you plead guilty, you waive the right not to incriminate yourself.
I do.
You waive the right to a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt?
I do.
You waive the right to confront and cross-examine witnesses.
I do.
You waive the right to put evidence on in your own defense.
I do.
All right. Do you understand that you waive the right to appeal?
I do.
All right, Mr. Taylor, the Commonwealth has made the following offer. Possession of a controlled substance, first degree, first offense. That is a Class D felony. On your plea of guilty, the Commonwealth would recommend a sentence of 2 years plus a possible fine and court costs. Possession of drug paraphernalia, a Class A misdemeanor. On a guilty plea, the Commonwealth recommends a 12-month sentence. Count. Let's see. The next count, operating on a suspended license. Commonwealth recommends a 90-day sentence. Failure to maintain insurance, the Commonwealth recommends a 90-day sentence. License plate not illuminated, the Commonwealth agrees to dismiss that. The total recommended sentence would be a 2-year sentence. The Commonwealth agrees to supervise probation of that sentence to last for a period of 2 years on the condition that you get an assessment from the social services clinician with probation and parole, and that you comply otherwise with the terms of probation and parole, which will include any recommendations that come out of that assessment, if there are any. Okay? Is that what you understood your agreement to be?
Yes, sir.
All right. Other than what I just told you, have you been promised anything to get you to plead guilty?
Nope.
Has anyone threatened you to try to make you plead guilty?
Nope.
Mr. Taylor, are you pleading guilty voluntarily?
Yes.
Are you acknowledging that on March 3rd, 2019 in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes.
Are you also acknowledging that at that same time and in that same place, you were operating a motor vehicle, knowing that your license had been suspended, revoked, or canceled?
Yes.
Also, that at that time, your vehicle or the vehicle you were operating was not covered by a policy of insurance required by law?
Yes.
All right. Believe that's got it. I'm going to accept your plea, and we are going to talk about where you go from here. I should have a probation officer on here to explain to you what you need to do. Well, I guess, Ms. Myers, I should ask you, did you all discuss him waiving a PSI and getting sentenced today?
We did, Your Honor, and he was agreeable to doing that.
All right. Mr. Taylor, I'll go ahead then, having accepted your plea and sentence you to 2 years, granting your request for probation to last for a period of 2 years. I will waive your court costs and your fine because you've been in custody and you have the public defender's office representing you. And Officer Bragg, tell Mr. Taylor what it is we need to tell him, okay?
It's actually me today.
Oh, okay.
Your Honor.
Sorry.
You're fine.
Officer
Okay.
Bragg, you're off the hook. Officer Mann, tell Mr. Taylor what you need to tell him.
I need you to call the office tomorrow morning and find out what you need to do from there, okay?
Okay.
And you can Google that number, or if you want Miss Bonnie down there to write it down for you, I can, or I can tell you it.
That's fine either way. I mean,
Okay.
probation
Then-
is right.
Yeah,
Okay.
just shoot it at, just fire it off. She's got a pen right there. She's ready to
Okay.
write.
It's 678-7443. And call by 9 a.m., okay?
Okay.
All right, Mr. Taylor, when all the ink dries on all this, they'll be letting you go down there. Be sure you take care of this like you're supposed to, okay? Do you have any questions?
No, I'm good.
All right. Thank you. Vicky Wilburn?
Judge, this is my motion to void diversion. If we could have a hearing on it.
Yes, sir. We are going to, our next available hearing date on this will be April 13th at 1:30. Mr. Barry, I cannot recall who.
I
will be
believe that's
handling
mine,
this.
Judge. I believe Ms. Wilburn was my case.
Okay. Yeah, I mean, we were here way back at the beginning of this month, which seems like a long time ago, but it was roughly 3 weeks ago. And Ms. Wilburn entered her plea at that time. I believe these are your initials. So the Commonwealth's filed a motion to void pretrial diversion. Hearing will be 4/13 at 1:30. Okay.
Okay.
Can I say something, Your Honor?
If you would like,
My grandma, you let me out a week before I went to rehab, and I got to spend a week with my grandma. And I thought I did everything right when I went to rehab. I talked to the director and told her that my grandma was dying. I mean, and she is. And the director told me, she called Rebecca Baird, which is the probation officer there in Henderson. Rebecca Baird said, as soon as I get to Metcalfe County, make sure that I call Charity. And I did. And I just wanted to spend some time with my grandma. And last night, when I called, they said that she was going unresponsive. Please don't let me be in here when my grandma dies.
I mean, that's not the same information that I got, or I wouldn't have done a warrant on you in the first place.
It's
I mean, you don't, that nobody claims or acknowledges that they gave you permission to leave your treatment facility.
I talked to Connie, and she talked to Rebecca Beard. The only thing I want to do is be with my grandma.
I understand. I understand. I mean, I don't know what the correct answer is right now, but I, you know, that's not the information that I got from your probation officer.
Well, I had COVID too, but I told Charity why I left. Can you send me home on an ankle monitor or something just until she passes? She went unresponsive last night. She's at home.
Well, I don't know. Let me talk to Officer Ford about it and I'll see. Okay. That's the best I can do right now.
All right, thank you.
All right, you're welcome.
You can send someone out to my mom's and check. I mean, you can see my grandma laying in that bed dying.
I understand. I understand. Okay. Who's you got right there? All right. Let's see. I guess we've made our way back around to Mr. Hicks. What? Yeah, I don't need him because he's got all the paperwork here. All right, Mr. Hicks, can you raise your right hand for me? Do you swear or affirm you will tell me the truth, so help you God?
Yes.
All right. Mr. Hicks, I've got several things to talk to you about here today. Start out with this. This is a motion to enter a guilty plea. Did you go over this?
Yes, sir, I did.
All right. Is that your signature?
Yes.
Okay. Did you have all the time you needed to discuss that with your attorney?
Yes.
All right, very good. Did you understand it when you signed it?
Yes.
Okay. In 20 CR 095, the Commonwealth has made an offer. It's on this document here. Does that look familiar to you?
Yes, it does.
And is that your signature?
Yes.
Okay. In 20 CR 098, is that your signature?
Yes, it is.
Okay, thank you. In 20 CR 103, is this your signature?
Yes, it is. Yes.
Sorry. Yeah. And in 20 CR 31, which is this one right here, is this your signature?
Yes.
Okay. Did you read over each of these documents that I've just shown you and discuss them with your attorney?
Yes.
And before signing them, did you make sure that you understood what you were signing?
Yes, sir.
All right. Mr. Hicks, you understand that you have the right to remain silent. You don't have to say anything that can be used to prove the charges against you. If you plead guilty, you are waiving that right.
Yes.
All right. You understand that you have the right to a jury trial where the Commonwealth has the burden of proving guilt beyond a reasonable doubt. You are waiving that right if you plead guilty.
Yes.
Okay. You have the right to confront and cross-examine the people that give testimony against you, and you waive that right if you plead guilty. Do you understand?
Yes.
All right. Do you understand that you waive the right to put evidence on in your own defense if you plead guilty?
Yes.
Finally, do you understand that you waive the right to appeal if you plead guilty?
Yes, sir.
Okay. Mr. Hicks, looking at these, hopefully in something amount, at least resembling numerical order here, 20 CR 31, the Commonwealth has made the following offer to you in writing, which you have signed. And we just got, there's a lot of different charges here, so we just need to go through them all and make sure that we understand each other, okay? Count 1, fleeing or evading police, first degree. That is a Class D felony. The Commonwealth recommends on a guilty plea a 3-year sentence plus a possible fine and court costs. Count 2 is DUI. That is an A misdemeanor. The Commonwealth recommends a 30-day sentence plus the possibility of a fine and a service fee. You would also get a license suspension and a requirement that you do DUI counseling. Count 3, driving on a suspended license. Commonwealth recommends a 90-day sentence. Count 4, failure to produce insurance card. Count 5, reckless driving. Count 6, speeding 26 or more over. And count 7, improper registration plate. Count 8, expired registration plate. Commonwealth agrees to a dismissal of each of those charges. Count 9, criminal mischief first degree, a D felony. The Commonwealth recommends a 3-year sentence. Count 10, criminal mischief second degree, an A misdemeanor, a 12-month sentence. Count 11, criminal mischief third degree, a B misdemeanor, a 90-day sentence. Count 12, persistent felony offender in the first degree. Commonwealth agrees to amend that to a persistent felony offender in the second degree, and that would have an enhancement of the sentence. There would be a 3-year sentence, which was enhanced to 5 years on the basis of that PFO second degree, plus the DUI sanctions and restitution in the amount of, looks like about $7,950.20. Is this what you understood the offer to be in this case?
Yes.
The Commonwealth, as part of the offer, is placing on the record that it opposes probation and shock probation. Do you understand that?
Yes.
All right. Mr. Hicks, have you been threatened with anything to try to get you to plead guilty?
No.
Other than the promises that the Commonwealth made that I just told you about, have you been promised anything to get you to plead guilty?
No.
All right. Are you pleading guilty voluntarily?
Yes, sir.
Mr. Hicks, are you acknowledging that on November 24th, 2019 in Berrien County, you committed the offense of fleeing or evading in the first degree when you were operating a motor vehicle and having the intent to elude or flee? You knowingly or wantonly disobeyed a direction to stop your motor vehicle given by a peace officer. By so doing, caused or created a substantial risk of serious physical injury or death to any person or serious damage to property.
Yes.
All right. Are you also acknowledging that at that same time and place, you were under the influence of a substance or combination thereof that impairs your ability to drive?
Yes.
Are you admitting that you committed the offense of driving on a suspended license by operating a motor vehicle knowing that your license had been canceled, suspended, revoked, or withdrawn?
Yes.
Okay. Mr. Hicks, with respect to the criminal mischief first degree, second degree, and third degree, are you acknowledging that you intentionally or wantonly defaced, destroyed, or damaged property, which a police cruiser causing damage of $1,000 or more?
Yes.
And then there was damage to property causing a loss of between $1,000 and $500, which is criminal mischief second degree, and damage to property under $500, which is criminal mischief third degree. Are you acknowledging those as well?
Yes.
All right, Mr. Hicks. Finally, are you acknowledging that you are more than 21 years old? You were more than 18 when the underlying offenses were committed, and you have previously been convicted of at least one felony in Barron Circuit Court?
Yes.
All right. Mr. Hicks, I am going to accept your plea of guilty in that case. In 20 CR 95, the Commonwealth's offer is as follows. Count 1, trafficking in a controlled substance, first degree, 2 or more grams. That is a Class C felony. The Commonwealth agrees to amend that to possession of a controlled substance, first degree, which is a Class D felony, and recommend a 3-year sentence. Commonwealth agrees to recommend a 12-month sentence on the Class A misdemeanor of possession of drug paraphernalia. The Commonwealth therefore would recommend a 3-year sentence in this case to run concurrently with all the other cases that we are going to discuss here today. And Commonwealth opposes probation and shock probation. Is that your understanding in that case?
Yes.
Other than that, have you been promised anything or threatened anything to try to get you to plead guilty?
No.
All right, Mr. Hicks, are you acknowledging to me that on or about November the 19th, 2019 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes.
Okay. Mr. Hicks, I'll accept your plea of guilty there, and let's move on to 20 CR 098. The Commonwealth's offer is as follows. Count 1, possession, first degree, first offense, a Class D felony. The Commonwealth would recommend a 1-year sentence. Count 2, drug paraphernalia, a B misdemeanor, a 12-month sentence. Count 3, fleeing or evading in the second degree, a 12-month sentence. Count 4, resisting arrest, a 12-month sentence. Count 5, fleeing or evading second degree, a 12-month sentence. Count 6, operating on a suspended license, a 90-day sentence. Count 7, no insurance, a 90-day sentence. Count 8, criminal trespass, and count 9, expired registration. The Commonwealth agrees to dismiss those charges. Total recommended sentence would be 1 year to be served concurrently, with all sentences except for 20 CR 031, which is the very first one that we talked about. Is that what you and the Commonwealth opposes probation? Is that what you understood the agreement to be in this case?
Yes.
All right, Mr. Hicks, are you acknowledging that on or about January 14th, 2020 in Barron County, you possessed knowingly and unlawfully methamphetamine
Yes.
and drug paraphernalia? Okay. Are you also acknowledging that on 2 separate occasions, you committed the offense of fleeing or evading, all on the same day, fleeing or evading in the second degree, once in a motor vehicle and once as a pedestrian, when you knowingly or wantonly disobeyed a direction to stop your motor vehicle given by a peace officer, or when as a pedestrian, you knowingly or wantonly disobeyed a direction to stop given by a peace officer?
Yes.
All right. Are you admitting that you committed the offense of resisting arrest when you intentionally prevented or attempted to prevent a peace officer from arresting you by using or threatening to use force?
Yes.
All right. Are you acknowledging that you were operating your motor vehicle knowing that it had been suspended or revoked?
Yes.
All right. That's all of those. All right, and then finally, 20 CR 103, the Commonwealth agrees to recommend the following. Let's see, possession of a handgun by a convicted felon, that's a Class C felony, the Commonwealth would agree to dismissal. Theft by unlawful taking of a firearm, a Class D felony, the Commonwealth would agree to dismissal. Theft by unlawful taking over $500, a D felony, the Commonwealth would recommend a 1-year sentence. And count 4, PFO first degree, the Commonwealth would agree to dismiss. Total recommended sentence in that case would be a 1-year sentence plus restitution of $2,575. Commonwealth opposes probation. This sentence would be consecutive with the 20 CR 31, but concurrent with everything else. Is this what you understood your agreement to be there?
Yes.
Mr. Hicks, are you acknowledging that over a period of time from January 13th to January 16th, 2020 in Barron County, you took or exercised control over movable property belonging to another person valued at $500 or more, but valued at less than $10,000 with the intent to deprive the lawful owner thereof?
Yes.
All right, then I'm going to accept your guilty plea in that case as well. Mr. Berry, what's your all's preference about sentencing moving forward here?
Judge, I think Mr. Hicks would rather go ahead and do the sentencing today and get it all wrapped up.
Okay. The only thing I don't want to do, because, you know, I'm just seeing all of these things for the first time, is, and I don't want anybody to take what I say as a gospel when I'm just kind of winging it, because, you know, some of these are concurrent and some of these are consecutive, and I would really need to sit down like I'm sure you and Mr. Hicks did and break down what was what, so that you know what he's going to serve. But I know that the first case was a 5-year sentence.
It should total up 7 years, Judge.
Yeah, I was going to say the first year was a 5-year sentence. The second one was, I believe you all said 2, but concurrent. The third one was 1 year consecutive, and the last one was 1 year consecutive. And in my mind, that seems like 7, but I didn't want to say something wrong.
Your Honor, that's the offer the Commonwealth made, was to resolve everything for 7 years.
All right. Mr. Hicks, do you understand that?
Yes, I do.
All right. So are you, Mr. Berry indicated, are you in agreement that you want to go ahead and get sentenced right now?
Yes, sir.
All right. Then I will accept that waiver of a PSI, and I will go ahead and impose those sentences today that I just now said. In the DUI case, you've got, certainly I'm going to waive his fines and his costs and all that, the service fee, you know, we'll just serve it out. You got restitution in 2 of those cases. I know you can't pay it right off the bat, so you'll just have to start paying that when you get out. We usually try to do something like probably $75 a month. And because I don't know when you're getting out, I usually give you 90 days before your first payment is due, so that you can get it, you know, your situation arranged and get yourself a job and all that stuff. Okay. All right. Do you have any questions about that?
No.
All right. If there isn't anything further, then we will get these judgments done, and that'll take care of it. All right.
Thank you.
Thank you. Yes. Bonnie,
Yes, Judge.
you have anybody else in the room there?
I've got Joseph Slayton.
Oh, he's not on my docket.
He's on the add-on, Judge. I'd filed a motion to revoke his bond based on a new arrest.
And Your Honor, just as a heads up, Danielle Cord's got her arraignment moved to this week, so there should be another jail inmate for that as well.
Oh. Well, I'm always the last guy to know these things. I guess, Mr. Richardson, what do you, I mean, I didn't have this on a docket, so I don't know what it, tell me what it's about.
He was on parole and he got a new arrest, Judge, but he had other bonds in other counties. And after talking to his probation or parole officer, I went ahead and filed this. I just saw he got a new indictment out of Logan County for bail jumping, so I don't think he's necessarily going anywhere.
Oh, no.
But I did want to go ahead and set a hearing date on the motion, though.
All right.
Now, can I say something?
Yeah, go ahead.
All right.
they reinstated my bond in Logan County because I was supposed to do Zoom court, but I didn't have no code to put in it when I got out in January. And the new arrest was over the failure to appear in Logan County. Only thing I'm doing now is just waiting on parole to send me to the Mark. They said the Mark Center to do SAP. That's what they posted. They assessed me Thursday. They said it should be like a week before they send me down there. That's where I was going to. But they're gonna hold me in here till they send me.
Judge, there's a lot of facts and conversations Mr. Slayton had with probation and parole I'd like to put on the record. That's why I wanted to have a hearing.
Well, we could, I mean, if you have filed the motion, you get to have a hearing, so we'll have it on, but the next time we'll be here is April 13th
That's fine.
at 1:30.
So what I need to do? Call a probation officer back? Tell them I can't go to rehab now.
I mean, we got probation officers on here. They can let you I mean, nobody's telling you can't go to rehab, but we're gonna have to hear what's going on, and and we won't do that till April 13th. So we'll have to wait till then to figure out what we're gonna do. All right. I thought we already arraigned her.
And Your Honor, she was set to be arraigned last week, and I was told that since I wasn't here for that, because she got indicted just the Thursday before, that we continued the arraignment today.
You might be right about that.
Hey, once in a lifetime today.
Yeah, you might, because I did talk to her, because when
And
I
she
called
mentioned the cat.
yeah, when I called the other, the co-defendant up, she walked up with him. And I think you may be correct that's what we told her, but it didn't make it
Yeah,
on.
court
the
date,
docket.
Judge, is showing that she's just got a pretrial conference set for, I
That's-
think, the same time that Manthy's got his, but I don't think she's been arraigned.
Yeah, I
That's
think
what
you're
I
right.
was going to point out too.
Is she, Bonnie, do you have her there with you, Danielle Cords?
No, but I can get her, Judge.
All right,
Can I say something?
Mr. Price will have to hold on a minute till they go get her, okay?
That's fine. I appreciate it.
Sorry.
Your Honor, why they're getting her, Kristen Barnett, she has a drug court review, and she's in aftercare at this point, so we don't need to dismiss that case.
Yeah, we'll put that down the road about 6 months.
And then Brandy Abbott's on for a sentencing, but I don't see her present.
We're gonna put Miss Barnett to 1025 for review. That's a little more than 6 months, but it is what it is. Brandy Abbott, is that what you said?
That's correct.
Okay. Yeah, well, you guys have sent her a notice that her court date was moved to April 12th. So I don't know how, I mean, I don't know what happened.
So that'll be on April the 12th then?
I guess.
Okay.
Judge Charles Underhill has been on for a while. He's on for final sentencing. I see his ceiling, but I don't see him.
All right. Charles Underhill. Yeah. I don't think I was about to jump off a really short wall. All right, Mr. Underhill, are you with us? All right.
We had it working a minute ago.
We're going to punt. Miss Colvin, are you with us?
She's been on here all morning. I don't know where she is.
I know. There's Mr. Underhill. He's back, I think. Mr. Underhill, can you hear? Can you hear me? Ooh, that's weird. I'm getting a real, like a To Kill a Mockingbird, Boo Radley vibe. I don't know what to do.
Okay.
Uh-oh,
I'm
we
here.
go.
You can go to Mary Colvin.
We might be on to, well, I already tried that.
I tell you what, this is the awfulest thing ever was.
Well, look here, just stay where you are, Mary, and don't make a noise.
I'm not, okay.
Until I get back to you, okay? I don't want to be turning anything on and off, just.
I know it's what I did and I didn't know what I done.
Yeah, don't turn anything off, okay?
Okay.
All right. Mr. Underhill, are you with me? All right, well. All right, Mary.
Okay.
All right, so did you get the chance to look at this pre-sentence investigation?
Yes, I did, sir.
Yeah. All right. Is there any reason that we should not proceed with Ms. Colvin's sentencing today?
Not as far as I'm concerned, Judge.
No, sir.
All right. Mr. Berry, if the, I think the sentencing recommendation was going to be a 5-year sentence in one case and 3 in the other to run concurrent. And Commonwealth agreed to supervise probation.
I believe that's correct, Judge.
Yeah.
Correct, Judge.
And with an assessment and all that, of course, in between there, I don't know how that'll work out because she's gone to treatment and everything, but that'll be part of what probation is going to talk to her about. Mary, are you still in Scottsville?
Yes, I am, sir. I'm
All right.
still in Scottsville for right now.
But you were planning on coming back to Barron County?
Yes. As soon as I
All
can
right.
soon as I get some money lined up, I'm going to move back closer to Glasgow.
All right, Mr. Berry, is there anything that you want to say other than to ask me to follow those recommendations?
There's not, Judge.
All right. Ms. Colvin, in 19 CR 611, your sentence was going to be a 5-year sentence plus a possible fine and costs. I'm going to waive your fine and your court costs. And I will do the 5-year sentence, grant your request for probation, and we'll probate you under supervision of probation and parole. In the 20 CR 131 case, that was a 3-year sentence, I believe it was. Yeah, and it was going to be concurrent. So I'll grant your request for probation in that case as well. I'll waive your fine and costs in that one also. Ultimately, you're going to be on probation here with probation and parole for the next 5 years, okay?
Okay, sir.
So listen, here's what we're going to do. I've got a probation officer on here, and I'm going to have her, I think Officer Mann's probably still with me. I'm going to have her jump on here and tell you what it is that she needs you to do. Miss Mann, Miss Colvin right now is living in Allen County, but her intent is to relocate permanently to Barron County. They just hadn't happened yet. Okay.
Okay. Mary, do you have a good number that we can reach you at?
Yes, ma'am. It's 270-303-9028.
Okay. And what is your current address?
It's 1172 Steenbergen. It's Steenbergen Road, Scottsville.
Okay. Do you have a piece of paper and pen?
Yes, ma'am, I do.
Okay. I want you to call our office, Barron County Probation and Parole, by tomorrow morning at 9 a.m. The number is 678
Okay.
7443.
Okay, hon,
Okay,
I'll do that. Thank you.
thank
Ms.
you.
Colvin, as long as you do all this that we're talking about and you keep your nose clean, you're not gonna have to see me anymore.
Well, honey, I hope everything goes well, and I don't plan on seeing you again unless I see you out in public. Say hello.
Yeah, well, that'll be all right. Okay?
Thank you very much, Judge.
All righty. Good luck.
Good. Thank you. Bye-bye.
Bye-bye.
Hey, Judge, I just realized that Jesse Turner was on for arraignment, but are we done with the jail? Was he?
No, they have started
Oh, okay.
doing certain cases different, separate times from other certain cases.
Okay, I was just making sure.
Well, I can't.
Open here, Judge.
All right. All right, let's see. Let's get Miss Cords up here. Okay, all right. Mr. Price, I don't know. Unfortunately, I didn't get like I said, her case kind of slipped through the cracks there on the docket, so I don't have her file here to go through her charges with her. I informed her what her charges were the last time, but I did not ask her if she wanted to waive a formal reading of her indictment or a formal explanation of her charges.
And Your Honor, I mailed those to the jail. I called over to the Commonwealth Attorney's Office and got a copy of those. She's charged with 1 count of human trafficking and 5 counts of complicity to possess or view a matter portraying a sexual performance by a minor. I would waive any reading or detail of those. I will talk to her and I'll make sure she understands those completely. I can confirm that.
Greg, I think it is 6 counts of the latter, but
It is. I apologize. It's 10 through 15, and I forgot to count the 10, Your Honor. So it is 6 counts.
That's how they get you.
As they stick it in there with the numbers.
Yeah, the numbers.
We had waived reading, Your Honor, enter a not guilty plea on all counts. Your Honor, asked to get a pretrial and get discovery, and I'd asked to be heard on bond as well.
Does anybody remember when the co-defendant is?
Your Honor, I just had it up. It's May, middle of May, I think.
Yeah, probably the 17th would be a guess.
And Your Honor, if we could set that pretrial after I discuss bond, I think that's going to have a lot of bearing on where we go, if you don't mind.
All right. Go ahead then.
Thank
please.
you. And Your Honor, she's a lifelong resident. She's almost 40 years old. This case started in reading the citation, and I'm going to be as clear as I can, but I have some information, but if I misspeak, it's not because I'm intending to, it's just to have limited information. So whenever I had an opportunity last week to meet with the Commonwealth Attorney, he invited Detective Bowe over. I think the investigation started in the beginning of February, Your Honor. She was cooperative. She actually met with the detective twice. She wasn't arrested for another 5 weeks after the investigation began. So there's no way that she's a flight risk. She was aware of the charges, aware of the allegations. She is on disability. The allegations are severe, Your Honor. But they're tenuous when you look at the facts that have been presented to me thus far. Right now, she's suffering from a car accident that she had in August, which is part of the facts that fall into this. Part of the facts are that the child was given a large sum of money, but that large sum of money actually came from the personal injury settlement that she received from that accident. She's scheduled to get wrist surgery. She's scheduled to get knee surgery, and she's suffering from both of those things. While she's not in the jail, she's not receiving any pain medication aside from Tylenol. So she's in a great deal of pain as we sit here now. Part of that was that from the accident, she has severe damage to her left foot, I believe it is. She actually went to the University of Louisville and had her big toe removed recently, and her foot is purple the last time I saw her, which was Thursday. We would be asking for a personal recognizance bond. All the allegations stem from Mr. Manth, who was the co-defendant. All the allegations, the complicity, I think from my understanding and from my discussions with the Commonwealth Attorney, are actually stemming from KRS Section 620, which is the abuse, neglect, and dependency, which is not that she actively participated, but that she knew and didn't report, which I think they're going to have a hard time prosecuting. The child that's involved in this, from my understanding, there is an active family court case that the child has been removed, and the child, I believe, has been returned to North Dakota where her mother lives. I can't confirm that. I just know that if she is released, Ms. Cords would have no contact with the alleged victim, no contact with the co-defendant. She has zero criminal record at this point. When I look at CourtNet, I can't even find a speeding ticket, Your Honor. This is not someone who is we all understand she is innocent as she's standing there. She's not going to leave, but even the allegations stem from the co-defendant's behavior, not so much hers, aside from reporting what she might or might not have known. So what I'd be asking for is a personal recognizance bond, Your Honor, so she can go home and get the medical care she needs. She's on disability, so she would be able to pay for home monitoring, but I don't know what she would be able to pay. She would be able to return back to the same home that I understand, but she'd also have the means to actually rent a new place if that would be necessary as well.
All right. Mr. Gardner?
Your Honor, obviously I disagree with Mr. Price's description that the ability of the Commonwealth to prove this case is tenuous at best. I think the evidence is actually fairly strong against Ms. Cords. She has admitted that she knew of the child pornography in her household, did not take any steps to get rid of that. They were living in a small apartment, if you want to call it that. It's actually an attic of a residence. She had equal access to the devices as Mr. Manth knew of what was on those devices and the type and nature of the images that were on the devices. Also, Ms. Cords is the connection to the juvenile victim in this case. She is friends with the child's biological mother, was friends with her. I think in Minnesota is where they previously resided. Mr. Manth did not have any connection to the juvenile victim in this case, except through Ms. Cords. There was an arrangement made where this child was transported from North Dakota back to Barron County, Kentucky. There were alleged sexual acts that occurred once in Barron County, Kentucky. And there was also an admission of Ms. Cords that there was at least $2,000 given to the child while she was in Barron County, Kentucky. Which is the basis of the human trafficking charge, Your Honor. So we believe that the evidence is strong, that the allegations are very serious, and that the bond, as said, is appropriate.
Okay. I will, it's always worthwhile or at least allowed, I guess I should say, to, if somebody hadn't been able to make bond and they're in custody, to ask me to review that, and I will. I don't know what exactly I think the appropriate thing will be to do. I usually, they're usually, when you have these arraignments and you have these hearings, there is information you find out from one side or the other, or maybe both, that you didn't already know, and that's just the nature of the way these things work. So I've got some things to think about, but I don't know what exactly an appropriate thing to do on the bond is, and I'll just have to take a look at it and see what I can, what I think is the correct thing to do. There may be I don't want to necessarily get anybody excited, but it is likely that I will make some kind of modification to it. I don't know if it'll be what it is, what she wants, but I don't know that it won't be either. So I'll just have to look. They're telling me that the prior time we were here, I put her co-defendant's case on for May the 10th. So I misspoke earlier when I guessed May 17th, but I was wrong, as May 10th. So if that's when you want me to put it, that's when I will. If you want me to put it some different time, I can do that.
In Your Honor, May 10th is actually the DPA
Good point.
That Monday goes through Tuesday, so I don't know if that's going to.
I just got an email on that. I didn't know all that when I said all these things. I got an email on Thursday, I think, about that. And boy, I was excited to get that. I was really happy.
Another issue, Your Honor, whenever you were here last week, you actually signed the discovery order last week, so giving the Commonwealth Attorney 3 weeks. So I know they're kind of a week behind, but could we come back on April the 19th? I can have that discovery and have some more motions filed. I have a bill of particulars. I filed that this morning. And I think there's going to be some suppression issues. I would just rather get it moving. And just another thing for the court, this is something that
I'm
also
sorry,
step-
can I cut in here 1 second? There was a motion for discovery and an order was signed. What was it?
It was signed last week when they thought the arraignment was going to be going on. So that's
No,
where
he's talking about the standard arraignment order that we do.
correct.
Okay.
I'm sorry.
There was an insinuation that the Commonwealth was behind on something. I just wanted to make
No,
sure.
no. I was saying that it was signed last week, so I didn't want anybody to think that there's a week lost. That's all I was saying.
Yeah, no,
But-
he's saying that there's been an order already signed, even though we just arraigned her today. The order was signed a week ago.
Okay.
Correct. And I spoke to the Commonwealth Attorney also. This is something that's going over into federal jurisdiction as well. So this is something that's going to be long running. So whenever the court looks at bond, I think she's in a situation that traditionally you would have somebody that could cooperate, but she is not without any kind of federal support to that cooperation. So she will be sitting for a long time if she's not giving a bond. And
Yeah.
that's why I'd like the time to kind of speed up if we can do the April 19th.
Yeah, April 19th is fine. At 1 o'clock.
At 1 o'clock, Your Honor?
Yes.
Thank you.
Now, Judge, are you going to move Manth to that date as well, or?
I forget. Greg, was that yours? Josh?
It's Josh's case, Judge.
Yeah. Josh, when we set Mr. Manthe, we set it on May 10th, and I did not realize that was the DPA conference. So
Oh, we see him on the 17th.
no, they tell me the 10th. I don't know.
Okay. I mean, if we want April 19th is fine.
All right.
With having no court next week, I should be able to go see him next week, so that should be good.
All right. We'll move his to April 19th as well, please. All right. Thank you.
Thank you, Your Honor.
Mr. Turner.
Yes, sir.
All right, Mr. Turner, you're here today because there has been an indictment from the grand jury in Berrien County charging failure to comply with sex offender registration first offense. I'm going to need to appoint counsel for you. I don't know, Greg. I don't know if you are able to do this one too.
I should, Judge. I don't.
Yeah. Well, I mean, I figured too, but I mean, there's new rules since I was, down there. All right. So, Mr. Berry, I'll appoint counsel for Mr. Turner on this charge.
Okay, Judge.
Judge, he currently has, in his other felony case, a pretrial on May the 24th, if he wanted to put it on that day.
Yeah, that's smart. I know he's got this deal going on in Monroe County, and I don't know what's going to happen over there, but they've got court between now and then, I think.
We do.
Was wanting to see if I could probably get a bond. Get my bond back, Your Honor. Please.
Well, you got a $2,500 cash bond on this case.
I can make it.
And I don't recall what's going on in the other case, and I don't really know what's going on in your Monroe County. I know you didn't have a bond there for a while. I don't know if that's still the case or not.
Yeah, I had a bond. I had a bond over there, but once I failed to make a phone call to comply, after D hit me with attempt to court here, D hit me with attempt to court up there. I'm pretty sure that if I was to get my bond back here, Judge Williams would probably give me my bond back there.
Judge,
What were you saying?
Last I checked on CourtNet, he had a no bond still in Monroe County.
When did you go back?
Going to.
When'd you go to court? Okay. Yeah,
sure I-
he's got court on April 15th over there.
Mm-hmm.
So, I mean,
I got the money to get my ankle monitor back and all that, and and pay the $2,500 cash bond here, and whatever Judge Wills wants me to do down there again. I mean, I can make my bonds. I'll just fail to make one phone call. I'm sorry, Your Honor. I made a mistake.
well, hold on. I mean, we can't relitigate the whole thing. We've already had a hearing on it. So,
Mhm.
I don't. Good Lord. This is just, yeah. But I don't know, Mr. Turner. Let me think about it. Okay.
All right.
All right.
About how long do you need, if you don't mind me asking? I don't want to aggravate you, man. I don't want to.
I need what I need.
Yeah.
I don't know. Okay.
All right.
All right. Thank you.
Judge, could we try Charles Underhill again? I have to get on to district court here in a
Yes.
minute.
Yes. Mr. Underhill, can you hear me? All right. Well, I've done all